Hello and welcome to Glasgow Loves the U. And this evening we're speaking with Open Rights Group. So James Baker's campaigns and grassroots activism manager. Dr. Monica Horten is policy manager. And we're speaking with Abby Burke, who's in org's data protection policy team. So Open Rights Group was founded in 2005 and is a UK-based digital campaigning organisation working to protect our rights and privacy and free speech online. So welcome to you all. And then we have Dee, who'll be taking your questions on social media. So if you have any questions, just put them on the social media. And then we've got Bernd, who's helping with us, helping IT. So first of all, James, I'll go to you first. So welcome.
Yeah, no, brilliant. Thanks for inviting us along. It's great to be here.
Yeah, and can you give us an overview of the work of Open Rights Group and why your work is important to our audience?
Of course, yeah. So Open Rights Group, it's a digital rights campaigning organisation. So we exist to protect everyone's rights in a digital age. And so much of what we do now of our lives is online and digital, isn't it? You know, every time we hear on the news, I mean, it's only today we're hearing about how Starmer wants the NHS to go completely digital and everything's digital. So in that digital world, it's so important that all of our rights are protected. And we all have those digital rights. You know, what do we mean by digital rights? Well, in particular, strong rights. Some of those are your human rights. So things like your right to privacy is one of your human rights, but also rights such as freedom of expression is a human right, and that's a very important online right. I think it's particularly interesting to an audience that is interested in issues around Brexit and the UK's relationship to the EU, because the whole thing around Brexit was around how the EU changes its relationship both to other countries, but also, you know, there's certainly a move with Brexit to change the relationship between the state and the individual and you know, the human rights as well, and kind of change those rights and regulations as to how we're governed as a country. So that's why I'd say it was interesting, you know, an interesting topic for your audience, and why it matters to your audience is because of that that changing landscape we find ourselves in, where, you know, even things like European Convention of Human Rights has been openly questioned by politicians who are, you know, of the same party of the government.
Mm-hmm. And can you tell us what campaigns you've been working on recently?
Yeah, so it's a really busy time for us here at OR, because there's a few bills that are progressing through Parliament at the moment. So our work is a mix between working on those bills that are progressing through Parliament, and they are the Online Safety Bill, which I'm sure a lot of people have heard of, and Monica's a real expert on. Also, Data Protection and Digital Information Bill, which is also passing through government, and that's the one which is really, you know, the Conservatives' attempts to rewrite the rules around our data post Brexit, and kind of have a, you know, they'd say free up enterprise and business, and we'd say, you know, trash people's data rights. On top of that, you've also got other stuff going through Parliament as well. You know, I think this week or last week in Parliament, there was a 10-minute rule bill on AI and workers' rights. There's stuff around digital market competition. You know, you might have seen the news today about Meta being fined for data. So there's a whole load of stuff which is constantly going on. On top of all of that, if we weren't busy enough, we've also got a huge program that looks at migrants' digital rights, because what we find, you know, we work particularly a lot of the stuff in intrusive, you know, opposing intrusive surveillance technology. And we find a lot of these technologies are trialed by the government first off on vulnerable groups of people. So we have a project looking at the digital rights for migrants, things like the Home Office's Challenge the Checks campaign. We also have a program that looks at what we're calling pre-crime. And what we mean by that is the increasing use of technologies such as AI, facial recognition, to try and almost identify people who are at risk of committing crimes before they've actually committed those crimes. So a kind of highly intrusive form of almost like predictive policing surveillance. And we find in the UK, again, that particularly targets people from vulnerable groups. People from kind of minority ethnic backgrounds as well find themselves disproportionately affected by this type of surveillance. So a lot of work there, and what we might call, the ongoing issues and reactions to things that are always happening in the tech world. It's such a fast moving scene with things like AI, facial recognition, new forms of surveillance coming out all the time. So it constantly keeps us on our toes, reacting to all of that stuff. So anyone interested, if you go on our website, look at the kind of what we're campaigning on section, we've got all our kind of main campaigns up on there, and you can kind of see them all easily and engage with them all.
Yeah, that's really interesting. I know from the coronation, I think there was something like 68,000 faces were mapped, but there was only 2 arrests. So it does seem like really disproportionate. So it's obviously really important work that you're doing. And Monica, maybe I'll turn to you now. Just wondering, like, how, in your opinion, did Brexit affect British citizens' rights online? Oh, you're on mute.
Yeah. Okay. Thank you very much, Jen, and thank you very much again for inviting us to speak with everyone in this live stream. I'll start with a very quick point, actually, about what we lost. Something I can positively say that we did lose as users and as consumers and as people who travel to Europe, but people may or may not be aware of this, and that is the right to what the EU calls content portability. This is actually the ability for you to take a Spotify subscription or a football subscription or a Netflix subscription even that you've purchased in the UK, take it away with you on holiday when you go to Italy or Germany or whichever EU member state you go to, and just listen as if you were at home. You don't pay any extra. We've lost that right now. So if people from the UK travel to the EU, you would either pay a premium or you wouldn't be able to get it, whereas the German on the sunbed next to you, I'm afraid, will have their Netflix like at home. That's a very easy one to cite as something we've lost. But the big context for what we're talking about today is actually much more important. And this is about the laws that the EU is making in the field of tech policy. And people may have heard of some of these laws. There was the Digital Services Act, which was passed recently about regulating the big tech platforms. EU is currently putting through what it calls an AI Act. So it's looking to regulate aspects of artificial intelligence. And there is, of course, the Digital Markets Act as well, which is another attempt to regulate big tech from a different perspective, from a competition law perspective. And of course, there is the GDPR, which was passed, well, officially in January 2016, and was going through the Parliament from 2012 through to 2015. And these are all, from the EU's perspective, flagship laws. These are really important pieces, not just really important pieces of law, but they are important for the EU because it sees itself as being very innovative from a legal perspective. And from the point of view of a country wanting to join the EU or even rejoin it or become a member of the single market, these are an absolute must-have. Any country that wants to join the EU would have to comply with GDPR, will now have to comply with the Digital Services Act and any of these other new pieces of law. And one of the reasons I can say that sort of fairly definitively is that back in 2015, I was working in Ukraine and also in Moldova and Georgia. I was working with the Council of Europe on an EU-funded project, and I was training them in EU telecoms law and in the GDPR, actually, and in these very pieces of law. And it was really quite clear that these countries who want to join the EU, and that I think was a microcosmic part of Ukraine's preparation to where it is now with its EU application filed, it was very obvious that this was an absolute must-have. And I think certainly if UK diverges on any part of tech policy, that would be an issue that would have to be resolved before the if the UK diverges, sorry, that would be an issue that would have to be resolved before the UK could rejoin. And just briefly to cite a couple of aspects of why that matters, there's the e-commerce directive, which regulates the internet, it regulates the broadband providers and also the online platforms hosting content. And there's the so-called liability shield, which means that the platforms only have to deal with content or take it down if they're told about it. So they're protected in a way. And the content that they host, they're protected from being sued, basically. And then you also have a general monitoring provision, a ban on general monitoring. General monitoring is about whether or not a broadband provider or a host can monitor the content, and it means all of the content of all of the users all of the time. And banning the states from imposing such provision is a really important protection of our freedom of expression, because monitoring content is an intrusion into your privacy and also a way of interfering with your freedom of expression. So really important laws to protect your ability to go where you want online, to do what you want online, to choose for yourself which content you actually want to look at. These are really fundamental principles of EU law, and as I say, they are an absolute must-have for joining or rejoining, and so a really important context for this discussion.
Brilliant. Okay, and then so you touched on divergence there, and I know we've all heard about the retained EU law bill, and obviously it's not going ahead in its original form. What do you think, in your opinion, how would that have affected British citizens' rights if it had gone ahead in its original form, and now that we know that there will still be 600 pieces of legislation that will be sunsetted?
There is one piece of law that is very important for us in the internet and in that context of protecting our freedom of expression. That law is the Open Internet Regulation. That's the EU name for it, and it's got more or less the same name in UK law. And this law was on the list of laws that were going to be sunsetting at the end of this year. It is not on the list of the 600. I have double checked that. But why is this law important? Because this law actually lays the foundation for something that is more colloquially known as net neutrality. Net neutrality means that the broadband providers, these are people like BT, like Vodafone, like EE, like TalkTalk, they cannot pick and choose what content they transmit to you. They have to carry everything. They can't say, oh, Netflix is going to pay us more money than some other provider of video content, therefore we will give preference to Netflix. They have to give equal treatment to all of the traffic. And that has been a really fundamental principle, again, in opening up the internet and making sure that we have all these wonderful apps and these wonderful services that we can access and that give us the stuff and the life that we'd like. And that is it's a very basic explanation of net neutrality. But the point being that these open internet regulations basically comprise EU law, and the law actually says that broadband providers, they may not block, they may not filter, they may not give preference, they may not discriminate against content. That's what it actually says. And it so it's a really important foundation. Now, the importance for us at the moment is that this open internet regulation and therefore net neutrality is actually in the UK-EU Trade and Cooperation Agreement. So it's in the treaty, and it's Article 178 of the Trade and Cooperation Agreement. And that means that the UK government will have to comply with this piece of law. At least that's how I read it. And I would read that any attempt by the UK government to change this net neutrality law in UK law would be a breach of the treaty. So I think that is potentially quite an important issue that hasn't yet had a lot of airing. Net neutrality is being consulted, or has been rather consulted on by Ofcom. And it is currently something that Ofcom is working on. But Ofcom has said that any decision on what to do about net neutrality law is left to the government. It's a political decision. So Ofcom will not be taking that decision. It is a political decision in the UK. Then if it is part of the treaty, then the government will have to bear that in mind. And it's something I think for us to be mindful of, again, because I say it wouldn't just be divergence, it would be a treaty breach.
Wow, that's so, yeah, I'm surprised that hasn't been in the media more actually. So we'll have to keep an eye on that for sure. I'll just hop over to Dee just to see if there's any questions from social media.
You're obviously wowing everybody at the moment because nobody's got any questions, so just keep going.
Okay, no worries.
That's all right.
All right, we'll move on to data protection. Then maybe Abby, then maybe you could take this question. Just in terms of the new data protection and digital information bill, should we be worried about that, or how will it affect our online lives?
Yeah, hi, thanks, Jen. And like Monica and James said, thanks again for having us tonight. The Data Protection and Digital Information Bill, or DPDI bill for short, is extremely worrying. Essentially, the government is adding to, repealing parts of, and altering UK GDPR, which is our one law that makes up part of our UK data protection framework. And EU and UK civil society organizations across a range of sectors have been expressing serious concerns over the past few years as the UK government has developed these proposals. In March, org signed an open letter with 25 other UK-based civil society groups protesting the bill. And I would say the general consensus across civil society is that the government is really squandering an opportunity to strengthen the UK's data protection regime post-Brexit, and is instead undermining public trust, furthering economic instability, and eroding fundamental data rights. Essentially, the bill gives a lot of power to the government and will make it more difficult for people to have control and oversight over their data and to challenge unfair uses of it. So I know a lot of people are probably pretty unfamiliar with the bill. We have a more in-depth briefing available on our website, but just to go through a few of the areas where we have concerns. One, the bill will greatly weaken data rights. The bill lowers the threshold for organizations to deny individuals the right to access their information, the right to erase their information, and the right to object to the processing of their information. So under the new bill, if requests are deemed excessive or vexatious by the government or a business, their requests can be refused. But this wording is extremely vague and ill-defined, and lawyers who have looked at the wording are certain that it will probably lead to more refused requests down the line. Additionally, the bill leads to lower protections around AI and automated decision-making. It also introduces new barriers for making complaints to the Information Commissioner's Office if you believe your data is being mishandled. And the data rights agency, AWO, actually estimates that complaints could now take 20 months or longer to resolve if this bill goes through. There's also another area that we're worried about is the massive undemocratic expansion of government powers. So the bill politicizes the Information Commissioner's Office by allowing the government to set out strategic priorities for the regulator, and also requires government approval before the ICO can issue codes of practice. So the ICO is critical in providing oversight to the government's use of data, as we saw during the COVID-19 pandemic. So the government could potentially use these new powers to ensure that the ICO looks elsewhere if it's doing things that they don't like. Additionally, the Secretary of State is given additional powers to introduce new grounds for processing and reusing data. The list of exemptions is overly broad and vague, and the government can also amend the list at any point. And for example, some of these exemptions are for things like crime detection and national security, but there's no further definition to what that means. Additionally, the Secretary of State will be able to approve international transfers to countries with weak data protection and a lack of enforceable rights and remedies. So in particular, to approve an international transfer, the new data protection test does not give any consideration to foreign legal frameworks around defense, national security, or what public authorities may do with personal data. And it also doesn't require the availability of any judicial redress. So that's all very concerning and leads to one of the biggest points, which is the potential loss of the EU adequacy decision. So the EU adequacy decision is based on the assumption of similar and equal levels of data protection between the EU and other countries. And that's what the UK currently has. This is a huge boon for businesses, researchers, but with this new bill, it will greatly weaken people's data protection rights and open new avenues for the UK to transfer data to countries with poor data protection, which could create a scenario where the data of EU citizens could be laundered through the UK to countries that the EU doesn't have an agreement with. This has raised huge red flags in Europe, and people are very concerned that the Commission may decide to revoke the adequacy decision if the bill goes through. And this would have really devastating consequences for the UK's economy. Conservative estimates found that just in legal fees alone, loss of adequacy would cost £1.6 billion and would really destabilize the economy. Businesses
Can you
would now...
Sorry, just to jump in
Okay.
there, if you could just explain what the adequacy decision means just for our audience.
Absolutely. So the adequacy decision is a decision between the EU and countries that it allows the free flow of data between. Basically, they look at a country, decide if it has a similar or equal level of data protection standards, and if so, they allow the free flow of data between the countries. This is really helpful. It means that researchers in the UK have access to data in the EU. They can, use that for health research, other scientific research. Businesses are also able to freely transfer data. And so this is something that we've had, since we were in the EU and GDPR came into effect. And so to lose this would mean that businesses would have to readjust. Some might relocate to the EU. And it would really create a large barrier between the UK and the EU, which is its closest trading partner. So I think, all of this is really coming from several places. One, the government is desperately trying to demonstrate that there are post-Brexit benefits, and tackling something like GDPR that is so synonymous with the EU is they're trying to make the point that an independent Britain can make its own rules on things like data, but they're really approaching this in the wrong way. Two, it's also very clear that the bill has been heavily influenced by large corporations who have been in closed-door meetings with the government. In Michelle Donnellan's speech announcing the bill that was published online, she mentioned several times that the bill was co-written with industry. However, there's no mention of civil society, and in fact, Oregon, over 30 other civil society organizations signed an open letter over a year ago now, criticizing the government and saying that, important civil society voices were really left out of the process of developing the bill. And then the third is, kind of going to James' earlier point about how much is going on. The bill is really situated within a larger authoritarian creep in the UK. We've seen numerous bills introduced over the last year that have impacted people's right to protest, impacted migrants' rights to safely arrive and reside within the UK. And so this is all part of, a greater power grab by the government and a erosion of people's fundamental rights.
Absolutely, yeah. And you mentioned there AI and discrimination. Can you just elaborate on that? How does the bill handle those issues?
Yeah, I'm happy to. The bill has really serious implications for AI and discrimination. It's increasingly common, as most people know, that AI is being used across legal systems, policing, healthcare, employment, and more. And algorithms are being created through training on a very specific set of data to reach conclusions about a wider community or population. And oftentimes these data sets and their resulting algorithms reflect the biases of the people creating them and of society at large. So there's a lot of evidence that's shown that AI technologies can replicate and exacerbate discrimination against marginalized groups. We've seen this in Amazon's recruitment system that disregarded applications from women. We've seen it in facial recognition systems used by the police that inaccurately detect people of color. And decisions can be made based on very little points of data that seemingly is irrelevant. The first part of your postcode, whether or not you like to post online. So you don't really need to provide a lot of sensitive information necessarily for an algorithmic decision to have a serious impact on you. And we also know that many times marginalized groups like migrants or low-income communities are testing grounds for various AI technologies before they're rolled out to the wider public. So to challenge these unfair uses of AI or prevent them in the first place, it's really critical to have well thought out and well tested systems that are transparent and accountable. So in this sense, the bill is going to pose very serious problems because it erodes the UK's data protection framework and key oversight mechanisms and really waters down data subjects' rights. So briefly, just a few specific things that will really impact AI and discrimination. Under Article 22 of UK GDPR, currently data subjects have the right to not be subjected to solely automated processing or profiling that could have a significant impact on their life, like access to education or employment or health services. But the new bill will really broaden the ability of the government and businesses to conduct automated decision-making, and it will make it a lot more difficult to seek redress against unfair decisions made by automated decision-making. As I mentioned earlier, the bill also makes it easier for organizations to refuse people's requests to access or control their data, and removes the ability for those likely to be affected by data processing to be consulted in the data protection impact assessment process. So these changes will make it more difficult for people to scrutinize and challenge the AI systems that are being used against them. Finally, the last really serious issue is that the bill abolishes several key oversight positions and mechanisms dealing with biometrics and surveillance. So in particular, the bill would abolish the biometrics commissioner role in England and Wales, and also repeals the duty of the government to publish a code of practice for public space surveillance cameras. So the current biometrics commissioner for England and Wales, Professor Fraser Sampson, has spoken out with his concerns, arguing that this would really diminish police accountability in their use of new AI technologies like facial recognition and voice pattern analysis that have shown to be discriminatory. And the Scottish biometrics commissioner has also spoken out as well. He actually wrote a letter to MP Carol Monaghan last week, arguing that if the role is abolished in England and Wales, police would have the ability to roll out mass public space surveillance or utilize discriminatory criminal justice algorithms that target marginalized communities. So this is raising a lot of concern across England and Scotland, all over the UK. So to wrap up, I think, yes, we should be very concerned about the bill's potential impact on AI discrimination. And to kind of touch on what Monica said about what we've lost post-Brexit, the EU's AI Act is taking a very different approach. It's currently in European Parliament now, and it includes bans on facial recognition in public, bans on predictive policing. It requires fundamental rights impact assessments and transparency for general purpose AI. So they're taking a much more rights-based approach to these technologies, while the UK is actually pulling back rights and, making these situations potentially a lot worse.
Yeah, I mean, we did have a live stream with James Farr of Worker Info Exchange last week, and he was kind of agreeing with everything that you said, and that has serious consequences for gig workers, but obviously affects everybody as well. So the other piece of legislation we're going to discuss this evening is the online safety bill. Maybe Monica, you'd like to explain the work that you're doing on that? Oh, you're on mute again.
Thank you very much. And I am actually going to pick up on quite a number of the themes that Abby was talking about, because they recur, in fact, through the online safety bill, the rights grab, the powers of the Secretary of State, or rather the intrusive powers of the Secretary of State, and the questions around automated decision-making all recur in the online safety bill, which started off as a bill to protect children online, but has now vastly expanded into possibly every area of life, and certainly is no longer limited to merely protecting children. And in fact, when you turn this bill upside down, if you like, and you look at it in the way that it's going to have to be implemented, rather than what the policy aim is, you find that it is a bill about surveillance, and it is about surveillance of people, of your public Facebook posts or your public social media posts. It is a bill about surveillance potentially of your private messaging, and also a bill about surveillance of your children. And taking each of those very briefly one by one. So surveillance of your public social media posts, we're looking at a requirement for the platforms to implement filters to stop people seeing what the bill defines as illegal content. And those filters would potentially sweep in and look at your content as you're uploading it and check it out. And if it happens to meet the criteria that the algorithms have got for what content is illegal, then that content could be removed before it even hits the platform. It's actually technically the only way they can comply with the requirement in the bill to prevent people from engaging with the content. And then if you're looking at surveillance of private messaging, this one is one you may have heard of in the news. You may have seen it reported, various reports about WhatsApp and Signal making various threats to leave the UK. The reason that they were behind those threats is a provision in the bill, which is means that Ofcom could require them to do a very similar kind of surveillance on our private WhatsApp and Signal messages. And it works actually in exactly the same way. It is the same kind of system. It's a filter that sweeps in as you're uploading your message and checks it out, and then takes a decision whether it carries on its way, or whether it is then diverted to somewhere else, and in the case of private messaging, potentially sent to the National Crime Agency. And so this would then be a very serious interference with your privacy rights, because it is breaching the confidentiality that you expect on these systems. But it also does something else technically, and that is that it creates the opportunity for security breaches in the encryption, what's technically known as end-to-end encryption, that protects your messages. So at the moment, WhatsApp and Signal cannot read the content of your messages. They do not know what it is, and they cannot store it. They cannot read it. And that means they can't scan it, because you can't scan encrypted content. So that's why they have to find ways either of looking at the content before you send it, before it gets encrypted, or they would have to break the encryption at some point on their server. And that creates what are known as backdoors in the system, or basically holes in the system, where bad actors like hackers and spammers and hostile states that don't like us very much and maybe want to interfere with our systems, they can then get into those systems. They can also do things like corrupting the database, and if depending on the implementation, it could also put your data on your own phone at risk. So that is an aspect of real concern for everyone. And then the question of scanning your children, I'll just say very briefly that the bill mandates what's age verification. So basically the government says to the platforms, you need to know the age of everyone on your platform, because you need to be able to identify if they're a child. And if they're under 18, then there'll be certain content they can see and certain content that they aren't. But they're also looking at different ages of children. So if is the child, is it a 5-year-old that you're being present that is trying to look at this content, or is it a 16-year-old? And if so, what difference would you make there, and what content could you or could you not show them? So that's in a very brief and very quick run through the online safety bill. But why is this important, and why does it make a difference with the EU? And I think that's what people here want to know. Now, it is quite different from the Digital Services Act. And one big difference is that the Digital Services Act does take a human rights or perspective. It places that really front and centre. It has a number of provisions that are designed to protect your right to privacy and your right to freedom of expression. Some of those are procedural rights, which means they, for example, the online platforms have to send you a notification if they are going to take down your content. And they have to notify you exactly what is the content they're taking down, what is the reason for them taking it down, and how you can appeal that decision. So if your content is targeted for removal, at least you know, and at least you know where you can appeal. And if people are unsure what I'm talking about, there will be some people maybe on this call who may know or who may have experienced the message which says your content does not comply with our community guidelines on whatever it is, terrorism or nudity or whatever, and so therefore we are taking it down. It's that kind of notification that you would expect. It's that kind of process, except that the process that you're seeing at the moment is one that is run by the platforms themselves. They manage it themselves, and it's their terms and conditions. This will be state mandated content, that state mandated standards, if you like, that they have to follow. And this, when I say state mandated, means the government is saying to them, here is the content that we are making, that we are saying is illegal, and because it is illegal, you have to take it down. And so it's basically the platforms are going to be operating on behalf of the state. At the moment, there isn't a very good process in the Online Safety Bill for what they have to do when they do take it down. So they're not actually particularly obliged to tell you, and they are not. There's a very basic obligation for them to run a complaints process, but no obligation for them to run a proper safeguarding, a proper process to allow you a right to appeal. As I say, this is a clear distinction between the Online Safety Bill in the UK and the Digital Services Act in the EU. And so in that respect, the UK will be diverging quite considerably from EU law in terms of the way it handles the fundamental rights aspects of our rights online and our rights to freedom of expression. And it is in line with what Abby was saying about the general attack on rights by this government. But the deeper issues go into the way that the platforms are being made liable. And in the EU has retained the old provisions that existed under the e-commerce directive that shield the platforms from liability. And so it has done a bit of a wiggle with something that it calls a Good Samaritan clause, which means that the platforms that voluntarily go around and look for bad content, if they do it because they're being a good Samaritan for the community, then that's kind of okay. It's a bit of a wiggle, really, a bit of a get out. But nevertheless, the platform liability position remains the same. In the UK, the platforms are going to be strictly liable for taking that stuff down, which means if they don't do what the bill requires them to do, they can be subject to heavy fines and they can be criminally liable. So their management who reside in the UK can be thrown into jail. So if you do not take down the pictures, and I'm going to give you this example, which the government itself has given, take down pictures of small boats in the Channel with carrying people in life jackets who are asylum seekers, then you could, potentially, ultimately be liable. You wouldn't be liable for one picture, but if you make a habit of not taking down this content or not addressing this type of content and the other offences in the bill, then your management could be liable. And just as an example, Jimmy Wales, for example, has commented on Twitter about this. And when he was questioned about it, he made the very sort of sharp comment. He just said, "I live here." Whereas Zuckerberg and people do not live in the UK. Jimmy Wales actually does live here. So he was obviously commenting that's why he would be quite worried about it, because as the person who ultimately runs the organisation, potentially he's the person who could go to jail. And so this is a very, very serious issue then about, and because of this liability, it incentivizes the platforms to take down more content, to take down content that might not be illegal, it might be completely lawful, but because they're worried about going to jail, or they're worried about getting the fines, they will then take down more content. So a person who lives in a seaside town, a concerned resident who takes a picture that they can actually perhaps see from their window, could then be suddenly find that their content is deemed illegal. It doesn't, however, actually criminalize the individual who's posted. It does mean that the content has to come down. But this is a clear divergence then from the EU position. And it is, I think, if the UK is looking at membership of the single market, UK will have to look at membership of the digital single market, and therefore it would have to comply with the EU position. So I think that is an issue. One other thing I would like to mention on the question of WhatsApp, of the WhatsApp monitoring and the monitoring of private messaging, the EU does have a proposal. It's called the Child Sexual Abuse Regulation. I think that's what its full title is. It's known as the CSA regulation. And this regulation is going to do something similar, but not exactly the same. And I think that's a really important point, because the British government says, look, we can do it because the EU is going to do it. Strange reversal of their usual position there. The EU is doing something bad, so we can do something bad too. But in fact, the EU regulation is quite different. It does deal a little bit with the fundamental rights of the users, and the way it's written is quite different. It's not a complete sort of blanket mass surveillance from the beginning in the way that ours is written. So there are some divergences there, but the really important thing to know is that the opposition in the EU is building. There are a number of EU governments, or like the French Senate, for example, has expressed an opinion which opposes this law. So although it's not yet decided, and my bet from my experience of tracking EU law for now 15 years is that it quite possibly won't go ahead. It doesn't mean they're going to actually publicly dump it, but what they often do is it just ends up on a digital shelf gathering digital dust, and that's quite possibly where that could end up. So, but it's one area to watch, where the position isn't quite so clear cut from the divergence position from in the way that we usually understand it.
Okay, it's interesting to hear about the two different approaches. It sounds like there might be a minor risk of the breach of the right to freedom of expression in the UK. But we'll just pop to social media and see if there's any questions coming in.
Well, there's a sort of a generic pulling together of some of the things you said about thinking of the MPs. Do you think they have any idea of the implications of even just what you've told us tonight? That, I mean, it just seems, I've learned so much in the last 40 minutes or so, and I'm absolutely terrified. And another one, which is about so a more kind of practical thing. What sort of practical things can us as individuals and can we share with people to help protect ourselves online?
Shall I have a go first, and then Abby can add?
Okay.
As far as the MPs on the online safety bill, they are very focused on the way that they have done it, which is they think it's about protecting children.
It's Molly Russell, isn't it? They just always talk about Molly Russell.
They talk a lot about the Molly Russell issue is really driving it, which is, I mean, obviously it's an absolute tragedy for the family, and no one disputes that. And to be honest, in that one's a really difficult one, because it went to the coroner, and the coroner has seen evidence of the kind of posts that Molly was seeing, and that has been, there is a report by psychiatrists and so on. So that one is a little bit different, because you've actually got evidence of the kind of content that would be considered harmful. And there is a different way that they could actually handle it with that evidence in mind. So, I mean, basically, the law basically says that if you're going to interfere with someone's right to freedom of expression, if the state is going to interfere with someone's right to freedom of expression, it can do so, but it must be to meet as the law says, a societal aim, to meet a need, an issue, a problem in society, or to address a problem in society. And it must be specific to that aim. So you can't just write a general law if you've got a specific problem. But if you can specify what it is you want to do, if you can specify the content that you want to remove, then the state can do that. And so I think this is where the state needs, this is what the bill doesn't do, quite frankly. And I think is what is not really understood. There's just a lot of talk about, there's a lot of abuse out there, so we've got to deal with it. So how do we deal with it? We get them all to take it down. Well, but then how do we no attention has been paid to defining it, because the conversation, when you listen to the MPs, stays at that very top level.
Exactly.
So that's my experience from the online safety bill perspective. And Abby, I'll hand over to you. If you have
Thanks,
anything
Monica.
to
I
add.
think I might actually pass it over to James. I know we're coming to the end of the live stream, so I thought, James, if you have any final thoughts as our campaigns and advocacy manager.
Yeah, I mean, obviously, I'm all about people taking action and doing things both to protect themselves and trying to achieve that political change. So I'd encourage, anyone watching, do go onto our website, have a look at the kind of what we campaign on section there. We call it like Stop the Data Discrimination Bill. So all Abigail's work around data protection is there. We've got some really easy to use tools so people can kind of write to their MPs. We've also got like a campaign pack that people can download, and you can read the campaign pack as to how you as an individual or working with a group of people can take political action around this. If you go on the publications section, then you've got briefings by both Monica and Abby and Mariano on these issues. So if you want to get stuck into the detailed analysis of these bills and educate yourselves around all the stuff they've been talking about, then do have a read of those. In terms of like how you can personally protect yourself online, probably recommend going to like a website like VPN Compare and having a look at maybe what VPN product might suit you, because that will help protect your personal privacy a little bit online and protect you from cyber attacks as well. I'd also recommend you have a look at EFF as an organization. Have got some really good online guides to privacy. But what I'd really say is just be mindful about where you're signing up to things with your own data. What services you use. I almost say, if you're not paying for a product, then you are the product in terms of advertising. People want to collect your data and make money from it. So unfortunately, it's one of these things, having more privacy focused online and tech solutions sometimes comes with a bit of a cost. But I would kind of urge people just to kind of be mindful of that when you're using your data, and especially if some of these bills do go ahead. If we are in a post-Brexit world where we don't have that protection that people who still have EU citizenship might have, if this bill passes, then I think it's going to be even more important that people take some of their own safeguards around their personal data and kind of take actions for themselves. So yeah, hopefully that's some kind of practical actions people can take, and a few kind of privacy tips for everyone listening.
That's brilliant. Thank you all so much for speaking to us this evening. There's so much going on that we'll have to keep an eye on. We'll absolutely visit your website just to keep up with everything that's happening. But we've learned so much in the last 45 minutes. Thank you so much.